On June 21st, the Supreme Court once again crapped on the Second and the 10th Amendment by upholding a federal law banning domestic abusers from owning guns. The implications are far-reaching. In typical fashion, the Supreme Court ignored the 10th Amendment and the Second Amendment that prohibits the government from enacting federal firearm laws in the first place. Instead, they harkened back to their bullshit decision in the 2022 New York v. Bruen ruling. The Bruen opinion said that firearm laws which violate the Bill of Rights are just fine. They will not be considered unconstitutional so long as they are, quote, consistent with this nation's historical tradition of firearm regulation, close quote. So, in other words, the Supreme Court relies on historical tradition instead of the Constitution they swore to uphold. Why don't the Supreme Court justices admit they use personal opinions to override constitutional restraints? The case, by the way, involved a Texas man named Zaki Rahimi, who had been involved in 5 shootings between 2020 and 2021. Rahimi pleaded guilty to the federal crime of possessing guns while subject to a restraining order, but an appeals court threw out his conviction. Their ruling was that possessing a gun is an outlier that our ancestors would never have accepted. The appeals court was simply following the court's ruling in the Bruen decision, but the Supreme Court twisted its own Bruen ruling into a pretzel to uphold this unconstitutional possession law. Chief Twister Justice Roberts said the appeals court erred by looking for a historical twin to the regulation rather than a historical analog. Excuse me? To his credit, Justice Clarence Thomas dissented, accusing the other justices of mixing and matching historical laws. He called it a regulatory blank check that allows the government to disarm its citizens. Thomas wrote that the court's ruling means the government need only find a historical law with a comparable justification to validate modern disarmament regimes. As a result, historical laws finding certain behavior could justify completely disarming a person for the same behavior. This is the same Supreme Court that upholds laws banning the possession of firearms by convicted felons, regardless of whether it was a violent felony or not. A simple tax error, or the commission of a felony you were not aware of, can disarm you and your entire family. The right to self-defense is the basic right to life, which no government can abrogate with firearm laws. And since a firearm owned by a family member constitutes constructive possession of a firearm by you, a felon's entire household is disarmed and defenseless. Eric Pratt, Senior Vice President for Gun Owners of America, summed up this outrageous crapping on Americans. He said, Zaki Rahimi is a dangerous individual already behind bars for real crimes, and that's where he should be. However, this ruling will disarm others who have never actually committed any domestic violence. So for those people to lose their enumerated rights, even for a temporary period of time, is a disgrace. If someone is dangerous, charge them with a real crime, convict them in a court of law, and get them out of society. I agree with Eric Pratt. The federal law in question didn't stop Rahimi from getting a firearm. It's a shame the moronic anti-gun protesters outside the Supreme Court can't understand that criminals don't obey gun laws. Down with liberty and self-defense, give us slavery and make us defenseless. In conclusion, what we are going to see is more gun raids where federal and local police shoot their way into people's homes to enforce unconstitutional firearm laws. The courts already allowed federal agents to get away with the mass murder of innocents at Ruby Ridge, Waco, and hundreds more. And we have not seen the end of it.